Good evening, ladies and gentlemen. Let's get started. Memorandum of Law on the Name. Many people are involved in diligent research concerning the use of the all capital letters for proper names in all court documents, driver's license, bank accounts, birth certificates, etc. Is the use of the all capital letters to designate a name some special English grammar rule or style? Is it a contemporary American style of English? Is the use of this form of capitalization recognized by educational authorities? Is this an official judicial or U.S. government rule and or style of grammar? Why do attorneys, court clerks, prosecutors, judges, insurance companies, banks, credit card companies, utility companies, etc. always use all capital letters when writing a proper name? Law is extremely precise. Every letter, capitalization, punctuation, mark, etc. in a legal document is utilized for a specific reason and has legal, i.e., deadly force consequences. If, for instance, one attempts to file articles of incorporation in the office of the Secretary of State of a state, if the exact title of the corporation down to every jot and title is not exactly the same each and every time the corporation is referenced in the document to be filed, the Secretary of State will refuse to file the papers. This is because each time the name of the corporation is referenced, it must be set forth identically in order to express the same legal entity. The tiniest difference in the name of the corporation identifies an entirely different legal person. It is therefore an eminently valid and possibly crucial question as to why governments, governmental courts, and agencies purporting to exist in some undefined, unproved manner within the jurisdiction of this state insist on always capitalizing every letter in a proper name. What English Grammar Reference Book says Manual on Usage and Style. One of the reference books obtained was the Manual on Usage and Style, 8th edition, ISBN I-878674-51-X, published by the Texas Law Review in 1995, Section D, Capitalization, Paragraph D, 1:1 states, always capitalize proper nouns. Proper nouns, independent of the context in which they are used, refer to specific persons, places, or things, ergo Dan, Austin, Rolls-Royce. Paragraph D, 3:2 of Section D states, capitalized people, states, state, and any other term used to refer to the government as a litigant, ergo the people's case, the state's argument, but do not capitalize other words used to refer to litigants, ergo the plaintiff, defendant, mason. Either no attorney, judge, or law clerk in Texas has ever read the recognized law style manual that purports to pertain to them, or the act is a deliberate violation of the rules for undisclosed reasons. In either ignorance of the law is no excuse, or violation, one violating the law he enforces on others is acting under title of nobility and abrogating the principle of equality under the law. They continue to write plaintiff, defendant, the state of Texas, and proper names of parties in all capital letters on every court document. English Grammar and Style Reference Book is found on only one reference to capitalization located within the glossary at proper noun, page 94, where it states, the name of a particular person, Frank Sinatra, place, Boston, or thing, Moby Dick, proper nouns are capitalized. There's an obvious and legally evident difference between capitalizing the first letter of a proper name as compared to capitalizing every letter used to portray the name. The American Heritage Book of English Usage. Here's a reference source. Within contemporary modern English, that states it is of an informal manner to write every word of specifically and electronic message, aka email, in capital letters. They say it's screaming to do so. By standard definition, we presume that that is the same as shouting or yelling. Are all judges, as well as their court clerks and attorneys, shouting at us when they corrupt our proper names in this manner? If so, what happened to the decorum of a court if everyone is yelling? Is the is the insurance company screaming at us for paying the increased premiums on the policy? This is doubtful as to any standard generalization, even though specific individual instances may indicate this to be true. It is safe to conclude, however, that it would also be informal to write a proper name in the same way. Does this also imply that those in the legal profession are writing our Christian names informally on court documents? Are not attorneys and the courts supposed to be specific, formally writing all legal documents to the letter of the law? If the law is at once both precise and not precise, what is its significance, credibility, and force and effect? New Oxford Dictionary of English, proper noun, also proper name. Noun, a name used for an individual, person, place, or organization, spelled with an initial capital letter, ergo Jane, London, and Oxfam. Name, noun, 1a, a word or set of words by which a person, animal, place, or thing is known, addressed, or referred to. My name is Parson, John Parson. Kowalser is the German name for lime water. Verb 2, identify by name. Give the correct name for the dead man has been named as John McIntosh. Phrase 3, the name of, bearing of, using the name of a specified person or organization, a driving license in the name of William Saunders. U.S. Governmental Styles Manual, the GPO. For those of you that don't understand what the GPO is, it's a government printing office, and it's the styles manual that is used to create statutes, codes, city ordinances, rules, and regulations, as well as amendments to the Constitution. It tells everybody exactly how the words are going to be used and what they mean, and what the punctuations mean, and how they are to be used, so everybody's on the same page. Because as I've articulated to you in prior videos, there is a law to grammar that is just as specific as mathematics, okay? U.S. Government Styles Manual is the spelling and usage of a proper name defined officially by U.S. government. Yes, the United States Government Printing Office, in their Styles Manual, March 1984 edition, the most recent edition published as of March 2000, which there was another one published, the GPO Styles Manual of 2016, ladies and gentlemen, but it is the same as the Government Styles Published Printing Manual of March of 2000. Provides comprehensive grammar, style, and usage for all government publications, including court and legal writings. Chapter 3, Capitalization, at subsection 3.2, prescribes rule for proper names. Proper names are capitalized. Examples are given are Rome, Brussels, John Macadam, Macadam family, Italy, Anglo-Saxon. At chapter 17, court work, the rules of capitalization as mentioned in chapter 3 are further reiterated. 17.1, court work differs in styles from other work only as set forth in this section. Otherwise, the style prescribed in the preceding section will be followed. After reading subsection 17 in entirety, I found no other reference that would change the grammatical rules and style specified in chapter 3 pertaining to capitalization. At subsection 17.9, this same official U.S. Government Styles Manual states, in the titles of cases, the first letter of all principal words are capitalized, but not such terms as defendant and appellee. Examples shown in subsection 17.12.12 are also consistent with the aforementioned subsection 17.9 specification, that is, all proper names are to be spelled with capital first letters, the balance of each spelled with lowercase letters. Grammar, punctuations, and capitalization. The National Aeronautics and Space Administration, otherwise identified as NASA, has published one of the most concise U.S. government resources on capitalization. NASA publication SP 7084, Grammar, Punctuation, and Capitalization, a handbook for technical writers and editors, was compiled and written by the NASA Langley Research Center in Hampton, Virginia at Chapter 4, Capitalization. They state in 4.1 Introduction. First, we should define terms used when discussing capitalization. All caps means that every letter in an expression is capital like this. Caps and LC means that the principal words of an expression are capitalized like this. Caps and small caps refer to a particular font of style containing small caps letters instead of lowercase letters. Elements in a document, such as headings, titles, and captions, may be capitalized in either sentence style or headline style. Sentence style calls for capitalization of the first letter and proper nouns, of course. Headline style calls for capitalization of all principal words, also called caps and LC. Here we see that in headlines, titles, captions, and in sentences, there is no authorized usage of all caps. At 4.4.1, capitalization with acronyms, we find the first authoritative use for all caps. Acronyms are always formed with all capital letters. Acronyms are often coined for a particular program or study and therefore require definition. The letters of the acronyms are not capitalized in the definition unless the acronym stands for a proper name. Wrong. The best electronic publishing system combined, what you see is what you get, would be WYSIWYG features. Correct. The best electronic publishing system combined, what you see is what you get, WYSIWYG features. This cites by example that using all caps is allowed in acronyms. Acronyms are words formed from the initial letters of successful parts of a term. They never contain periods and are often not standard. So that definition is required. Could this apply to lawful proper Christian names? If that were true, then John Smith would have to follow a definition of some sort, which it does not. For example, only if John Smith, all capital letters, were defined as John Orley Holistic Nutrition of the Smith Medical Institution to Holistics, John Smith, would this apply. The most significant section appears at 4.5, Administrative Names. Official designations of political divisions and of other organized bodies are capitalized. Names of political divisions: Canada, New York State, United States, Northwest Territory, Virgin Islands, Ontario Province. Names of government units: U.S. Government Executive Department, U.S. Congress, U.S. Army, U.S. Navy. According to this official U.S. government publication, the states are never to be spelled in all caps, such as New York State. The proper English grammar and legal style is New York State, with a proper capital letter at the beginning of each word indicating a proper noun. Reviews Manual on Usage and Style, the Usage of Legal Fictions, the Real Life Dictionary of the Law. The author of the Real Life Dictionary of the Law, Gerald and Kathleen Hill, are accomplished scholars and writers. Gerald Hill is an experienced attorney, judge, and law instructor. Here is how the term legal fiction is described. Legal fiction, noun: a presumption of fact assumed by a court for convenience, consistency, or to achieve justice. There is an old adage: fiction arises from the law and not law from the fiction. Orrin's Dictionary of Law. From Orrin's Dictionary of Law, published by the West Group, 1999, within the definition of fiction is found, a legal fiction is an assumption that something that is or may be false or non-existent is true or real. Legal fictions are assumed or invented to help do justice. For example, bringing a lawsuit to throw a non-existent John Doe off your property used to be the only way to establish a clear right to the property when legal title was uncertain. Merriam-Webster's Dictionary of Law. Merriam-Webster's Dictionary of Law 1996 states, legal fiction, something assumed in law to be a fact irrespective of the truth or accuracy of that assumption. Example, the legal fiction that a day has no fractions. Fields versus Fairbanks, North Star Borough, 818 P.2D 658 1991. This is the reason behind the use of the all caps when writing a proper name. The U.S. and state governments are deliberately using a legal fiction to address the lawful, real flesh and blood man or woman. We say this is deliberate because their own official publications state that proper names are not to be written in all caps. They are deliberately not following their own recognized authorities. In the same respect, by identifying their own government entity in all caps, oh, you little bastard, that little fly, in all caps, they are legally stating that it is also intended to be a legal fiction. The use of all caps for writing a proper name is an intentional style for what is apparently a predetermined usage and, at this point, unknown jurisdiction. The main key to a legal fiction is assumption as noted in each definition above. Conclusion. There are no official or unofficial English grammar style manuals or reference publications that recognize the use of all caps when writing a proper name. To do so is by fiat within and out of an undisclosed jurisdiction by unknown people for unrevealed reasons by juristic license of arbitrary presumption not based on fact. The authors of the process unilaterally create legal fictions for their own reasons and set about to get us to take the bait, fall for the deceit, assumption of the legal fiction. An important issue concerning this entire matter is whether or not a proper name perverted into an all caps assemblage of letters can be submitted for a lawful Christian name or any proper name such as the state of Florida. Is this assertion of the all capital letters name legal? If so, from where does this practice originate and what enforces it? A legal fiction may be employed when the name of a person is not known, and therefore using the fictitious name John Doe as a tentative or interim artifice to surmount the absence of true knowledge until the true name is known. Upon discovering the identity of the fictitious name, the true name replaces it. In all cases, a legal fiction is an assumption of a purported fact without having shown the fact to be true or valid. It is an acceptance with no proof. Simply to assume is to pretend. Orrin's Dictionary of Law says that the word assume means to take up or take responsibility for, to receive, to undertake, see assumption, to pretend, to accept without proof. These same basic definitions are used by nearly all of the modern law dictionaries. It should be noted that there is a difference between the meaning of the second and the third definition with that of the first. Pretending and accepting without proof are the same understanding and meaning. However, to take responsibility for and receive or assumption does not have the same meaning. Orrin's defines assumption as formally transforming someone else's debt into your own debt. Compare with guarantee. The assumption of a mortgage usually involves taking over the seller's mortgage debt when buying a property, often a house. Now, what happens if all the meanings of the words assume are combined. In a literal and definitive sense, the meaning of assume would be the pretend acceptance without proof that someone has taken responsibility for, has guaranteed, or has received a debt. Therefore, if we apply all of this in defining a legal fiction, the use of a legal fiction is an assumption or pretension that the legal fiction named has received and is responsible for a debt of some sort. Use of legal fiction John P. Jones in place of the proper John Paul Jones implies an assumed debt guarantee without any offer of proof. The danger behind this is that if such an unproved assumption is made, unless the assumption is proven wrong, it is considered valid. An assumed debt is valid unless proven otherwise. An unrebutted affidavit, claim, or charge stands as the truth in commerce, in maritime admiralty law. This is in accordance with the Uniform Commercial Code, valid in every state and made a part of the statutes of each state. A name written in all caps resembling a proper name but grammatically not a proper name is being held as a debtor for an assumed debt. Did the parties to the complaint incur that debt? If so, how and when? Where is the contract of indebtedness that was signed and the proof of default thereon? What happens if the proper name, i.e. John Paul Jones, answers for or assumes the fabricated name, i.e. John P. Jones? The two become one and the same. This is the crux for the use of the all caps names by the U.S. government and the states. It is the way that they can bring someone into the de facto venue and jurisdiction that they have created. By implication of definition, this also is for the purpose of some manner of assumed debt under the doctrine of idiom sonum. It looks the same, it sounds the same, it must be the same, let's roll on. Why won't they use the state of Texas or John Doe in their courts or on driver's license? What stops them from doing this? Obviously, there is a reason for using the all caps name, since they are very capable of writing proper names, just as their own official styles manual states. The reason behind legal fictions is found within the definition as cited above. The legalities of the all caps letter names. We could go on for hundreds of pages citing the legal basis behind the creation and use of the all caps letter names. In a nutshell, fabricated legal persons, such as State of Texas, can be used to fabricate additional legal persons. Fictions arise from the law, not the law from fictions. Bastard legal persons originate from any judicial governmental actor that wish to create them, regardless of whether he, she, it is empowered by law to do so. However, a law can never originate from a fictional foundation that does not exist. The generic and original U.S. Constitution was validated by treaty between individual nation states. All of the states are artificial corporate entities since they exist in abstract idea and construct. Contained within it is the required due process of law for all the participating nation states of that treaty. Representatives of the people in each nation state agreed upon and signed it. The federal government is not only created by it, but it is also bound to operate within the guidelines of the constitutional due process. Any purported law that does not originate from constitutional due process is a fictional law without validity. Thus, the true test of any American law is its basis of due process according to the organic U.S. Constitution. Was it created according to the lawful process or created outside of lawful process? Executive orders and directives. For years, many have researched the lawful basis for creating all caps juristic persons and have concluded that there is no such foundation according to valid laws and due process. But what about those purported laws that are not valid and have not originated from the constitutional due process. There's a very simple answer to the creation of such purported laws that are really not laws at all. Executive orders and directives, they are color of law, without being valid laws of due process. These executive orders and directives have the appearance of law and look as if they are laws, but according to due process, they are not laws. Rather, they are laws based on fictional beginnings and are the inherently defective basis for additional fictional laws and other legal fictions. They are regulated and promulgated by administrative code. Administrative code, by administrative law judges, by administrative law clerks, by the de facto program that's been set in place where they use statutes, codes, city ordinances, rules, and regulations, and they use an administrative law judge and an administrative law clerk to fabricate this fiction to tie it to penal sums and penal bonds so they can draft new money into the economy, okay? Rules and procedures, not due process. Currently, executive orders are enforced through the charade known as the Federal Administrative Procedures Act. Okay? Are you paying attention? Are you starting to figure it out a little bit? It's not hard. It's not rocket science. It just takes some proper guidance, and there's no exception to reading for yourself, ladies and gentlemen. This is what I do day in and day out. For 15 years, I've just sat here and read, and then I've turned around and used what I've read and learned and put it into practical application. Knowledge without execution is worse than a broke dick at a porn concert, all right? You're absolutely, utterly useless. To have the knowledge and not use it is to be complicit with what's going on. Each state has also adopted the same fatally flawed administrative laws. Now, this is important. The Chevron deference case just got overturned, ladies and gentlemen, and this is what they're fucking talking about. Okay, I need you to pull your heads out of your asses, quit thinking you know something, and start getting in these books and putting applied, gained knowledge into action. All right, and that's what my last few series of videos over the last few days is about, is how to remove judges from the bench, because they're really not judges. They're administrative law clerks, administrative law judges. They're ministerial administrators operating under the executive branch, administering a Chapter 11 bankruptcy for their defunct corporation, for which, ladies and gentlemen, the American people are the creditors. We back it. We back the whole thing. We are preferred stockholders. We have special drawing rights. Executive Order 100 under the Lieber Code clearly fucking points it out. Article 2, Article 31, Article 38. All right, if that isn't enough for you, you need to go look at 40 Statute at Large, 411, Section 7E, but don't just limit yourself to 40 Statute at Large, 411, Section 7E. You also just need to read the whole entirety of 40 Statute at Large, 411, all right? And understand that it's the trust indenture, all right? It's under military doctrine, under military occupation, all right? But there are rules to engagement, and they follow these rules to a T, and as soon as you learn the rules, the shit stops. All right. Lincoln established Executive Order 85 years after the independence of the United States. 7 southern nation states of America walked out of the second session of the 36th Congress on March 27, 1861. In doing so, the constitutional due process quorum necessary for Congress to vote was lost, and Congress was adjourned sine die, without a time to reconvene. Okay, now this is important. This is shit you're not going to learn in school. They don't teach you this stuff. Okay, the people that know this information have taken it upon themselves to research it and find it for themselves. This isn't something they share in the public education system, all right? Under 1861, when they adjourned sine die, that means without a time to reconvene. That doesn't mean they didn't have the power to reconvene on their own. Okay, but they chose to reconvene under an executive order. And when they did that, they became the advisors to the commander-in-chief for the largest defunct corporation in the world, okay? The United States, all right? And that's to come in 1871 under the Reorganization Act. Remember, everything they do is planned 50 to 60 years into the future, all right? In 1861, when they adjourned Sendai, perhaps the actual Congress didn't know what was going on in the background with the elitist bankers trying to figure out how they were going to get a stranglehold on this illusion of freedom and independence, right? From the king, from the monarchs. So they were finding a way to subvert it and get around it. And how they figured it out was through the executive orders, all right? We didn't win the War of 1812. If you go back and you actually research it, you'll find out that all the 13 colonies were British colonies. And even though they created these things called states, they very quickly succumb back underneath with the Reorganization Act of 1871. You have to understand that constitutions are corporate charters, no different than the East Indian Company or the Walmart or Target or Sam's Club, all right? They've got articles of incorporation, corporate charter, bylaws, a constitution, if you will, all right? So when Congress reconvened under the executive order, okay, they became the advisor to the commander-in-chief, who has the world's largest, strongest military force, okay? There are only 3 sovereign city states. You have the city of London, which, what a coinkydink. When they burnt down London, yeah, I said it, they burn it down. They engaged in arson. They cleared some ground, all right? Just like on 9/11. They brought that down intentionally, ladies and gentlemen. If you think that was some boogeyman is walking around in Jesus kickers clear out in the middle of the dunes, you're absolutely freaking, there's no words for it. If you really believe a bunch of people walking around in Jesus kickers decided to throw a towel on their head and come over here and fuck up some buildings with some fucking aluminum planes and jet fuel, all right, that doesn't even burn hot enough to melt fucking iron, you're a fucking idiot. All right? That was an inside job. It's an inside job. All wars are bankers' wars. If you don't think that was a fucking inside job, you've lost your fucking rocker. The military-industrial complex is a fucking business. All right? So, let me get back to it. This lesson here. So when the Congress reconvened under the executive order, they became the advisors to the commander-in-chief. When the judiciary branch sat on their ass and chose to remain silent, they then and there became the administrators of the bankruptcy. Okay? Now, this should help you understand why they're operating in law of merchant, law of mercantile, maritime admiralty. All right? Because in maritime admiralty, they're allowed to presume and assume. There's no need for fact pleading. They completely subvert the Constitution. They're operating in a completely different foreign and jurisdiction that, quite frankly, you're only subject to by your lack of knowledge, your ignorance, or you volunteer, or you actually work for them. Okay? So people running around calling themselves Democrats and Republicans are bold-faced fucking liars. And here's how I can prove that. If you don't get a check from the Treasury as a Republican or a Democrat every month, every 30 days, then you're a fucking liar. You can't be a Democrat or a Republican without receiving a fucking check, because it's an occupation, ladies and gentlemen, that makes you subject to the statutes, codes, city ordinances, rules, and regulations they passed after the Reorganization Act of 1871. Okay, now that we've discovered the truth about the fucking history, let's go on. Or without delay. This meant that there was no lawful quorum to set a specific day and time to reconvene, which, according to Robert's Rule of Order, dissolved Congress. Now, again, I just explained to you, Congress still had the power to reconvene under their own fucking authority, under the Constitution, okay? They chose not to. The executive order caused them to say, hey, well, if the commander-in-chief, who's no longer acting as the president of the United States of America anymore, feels it important to, by executive order, draw us back into chambers, then we'll do that. What they could have done is say, we're not going to reconvene under executive orders. We're going to reconvene under our own authority, and nothing would have changed in 1871. They chose not to for whatever reason. Okay. So just understanding the fact that they had the authority to reconvene under their own power and chose not to is how we get into 1871 under the Reorganization Act. This dissolution automatically took place because there are no provisions within the Constitution allowing the passage of any congressional vote without a quorum of the states. Lincoln's second executive order of April 1861 called Congress back into session days later, but not under lawful authority or lawful due process of the Constitution, solely in his capacity as what? Commander-in-Chief of the military. All right? Lincoln called Congress into session under authority of martial law. All right? So we've always been in a scenario, there are 3 stages of martial law. It's kind of like soft porn, full-blown porn, and hardcore porn, all right? Right now, you're in a state of soft martial law, okay? And this is why everybody's required to have licenses and insurance and all of that stuff. It finally got put into full force and effect after 1933, all right? And you got to understand the series of bankruptcies that happened and what the definition for a constitutor actually is. A constitutor is somebody who rolls debt over from one entity to another. All right? So, and yeah, I know my antics are crazy, but that helps people fucking remember it. If I'm rough as a cactus wiping your ass, you tend to remember not to use that same cactus. It tends to linger in your mind for a while. You know, if it's 60 grit sandpaper you're wiping your butthole with, you'll make cognitive notice that, hey, I don't want to use that leaf anymore. That son of a bitch hurt, right? So, since April of 1861, Congress has not met based on lawful due process, all right? This is why I tell you guys, I only pay attention to the first 10 amendments. The first 10 amendments are the fucking law. All right? Never mind that there wasn't an organic 12th and 13th Amendment prior to them fucking it up and doing the Reorganization Act, but I need you to understand the difference between the corporate world, the public side, the business, the capitalism, all right, which is where they created the United States so they could go and do business internationally, all right, and the de jure side that is still there. A republic for which you are guaranteed. It can never go anywhere. The power to create is never greater than its creator. Congress, the commander-in-chief, the Senate, the House of Representatives, and the judiciary did not have the authority to abolish the organic documentation and the very foundation of this great republic. All right? It's still there. And you can still use it. And I'm going to show you how eventually. Since April of 1861, Congress has not met based on lawful process. The current Congress is a legal fiction, all right, based on nothing more than meritus than yay. So what are you going to do about it? Having a monopoly on the currency. See, when they did the Reorganization Act in 1871, and then they turned around and came back in and redefined what money was in 1933, what the de facto had actually done is created their own banking system, okay? So all these mega corporations are involved in creating and have an interest in the IMF, the International Monetary Fund, and the global banking system, all right? They are human farming. That's why it was at once called Human Resources through DHHS, which is directly linked to agriculture and the Department of Commerce. That's why when a baby is born, the application and certificate after going through the state registrar is sent to the Department of Commerce, the Department of Agriculture, and the DTCC, and the DTC in New York, ladies and gentlemen. All right? Just hear me out for a minute. I'm going to paint you a pretty little fucking Picasso. Having a monopoly on the currency. What is the new currency, ladies and gentlemen? It's your precious valued time commodity. That's right. Your precious valued time is a commodity that has been pledged to the IMF. The alleged judiciary is not a judiciary. They're operating under the executive branch as administrative law clerks, administrative law judge, ministerial administrators, all right? And you go, well, where did they get this authority? Where did they get this power? Okay. It's all right there in the Constitution, ladies and gentlemen. It's all right there in the Constitution where it says any controversy. That's what the lower courts were created for. When Congress decided to create the lower inferior courts, it was for any controversy. It was to settle maritime and admiralty claims. It was to settle contract disputes, ladies and gentlemen. They are subjecting you to contracts that do not exist. And under presumption and assumption through maritime and admiralty law, the presumption stands unless rebutted and rebuked, or unless you force their hand to prove it, which exposes what they're doing. Okay? And there's a number of ways of doing that. And there's also ways of getting paid for it as well. Because remember, under the Treaty of Ghent, Article 10, involuntary servitude, peonage, bondage, and slavery shall no longer be had. Under the Charter of the Forest, we are free. Under the King's Charter, okay, under the Treaty of Ghent, Article 10, it's by the Britannic Magistry that separates the difference between the subject serfs of the British Empire and monarchy and the American people who are free. Kings without subjects, ladies and gentlemen. Now, people go, well, how can you use the Treaty of Ghent, Article 10? Well, it's very simple. Article 6, Section 1 of the Constitution. You got to go read it. Article 6, Section 1 says all the treaties and the prior constitutions that were created still are in force and have force, weight, and effect herein today and forevermore. And I'm paraphrasing that at the end. It doesn't say herein today and forevermore. They literally took and integrated, when we formed a more perfect union, the Federalist Papers, the Anti-Federalist Papers, all the treaties and all the constitutions prior still have the force, weight, and effect of the law of the land. All right, so when we're talking about law, let's talk about law, actual law. Nature's God, all right? God's law, okay? And we go back and we look at the documentation and we see that the documentation lays down a strict foundation and guidelines that they're not allowed to cross. They are servants, ladies and gentlemen, and you got to put them back in that jurisdiction, because in that jurisdiction, they made a shortfall with a sudden stop. In maritime admiralty, they have all this illusion of immunity. They try and usurp your foreign sovereign immunity, and they try and usurp it for themselves. And they say it's for the greater good of mankind. It's for the greater cause, all right? But in reality, you can put their happy asses back in the juror side and say, would you like nylon or hemp? Which one you want to swing by? Nylon bounces a little bit. Hemp, well, that's a stiff one, all right? And the choice is yours. And you can literally remove these people from the bench. They're operating in dishonor. They're using artifices and schemes with a false conveyance of language to convince you to become surety for the debt they manufactured and created by the negotiable instruments they drew up in their private ad hoc for-profit corporations utilizing the UCC in order to negotiate negotiable instruments in maritime admiralty law where presumption and assumption rule. All right? That's why you have a hard time in the public venues under the United States and the state of ever holding anybody accountable, is because they've exempted themselves, which is not what the Constitution ever said. The Organic Constitution said when they operate outside the law, there are consequences. All right? So having a monopoly on currency, law, and what passes for government and most of the world's firepower, the motto of the powers that be is, we've got what it takes to take what you've got. We've got what it takes to take what you got. Think about this for a minute. Knowing that they're charging you up under statutes, codes, city ordinances, rules, and regulations, they're charging up the ens legis entity, right? But if you go in there and you say, well, I refuse to claim that constructive trust you created. I refuse to claim that name. I didn't create it. I want to know who carries the primary active degree of fault and liability for creating it. Oh, contempt of court. Well, that right there, ladies and gentlemen, is unbecoming of a judge. All right. That conduct right there is malicious in its nature. Malicious prosecution, dereliction of duty, mixed war against the Constitution, mixed war against the people. It's espionage. It's an attempt to overthrow the Republican form of government we are guaranteed. All right. It's identity theft. It's kidnapping, extortion, money laundering, securities fraud, embezzlement. All right. These things I speak of with conviction only because of my 15 years in the fucking field. I have seen it all. Most people that call me for consult, I say, hey, look, just let me stop you right there. I've heard every fucking sad sob story you could ever fucking imagine in 15 years. There is nothing you are going to say that is going to fucking have me awestruck. Do you want the remedy, or do you just want to bitch about the problem and squander your precious valued time commodity? The choice is yours. Because I like providing remedies. What are remedies? Remedies are rights. Rights are remedies, and property is rights. All right. Without one, you can't have the other. All right. A remedy is because your rights have been violated, and there is guaranteed a remedy. For every trespass on a right, there is absolutely, equivocally, 100% without fucking question, a remedy that leads to the restoration of your rights. Sometimes it comes in the form of an estoppel. Other times it comes in form of monetary compensation. Sometimes it comes in the form of a restraining order. Okay. Other times it comes in the form of completely deleting any files or records they may hold or have on you that are causing you harm, damage, loss, or a hardship. Okay. So there's a lot of remedy here, ladies and gentlemen. It's not always just monetarily. Sometimes you need to look at the greater picture, especially dealing with gun-toting morons with an IQ of 70 that euthanize unarmed, innocent people day in and day out. Maybe you just want to be stricken from their fucking system so you're not caused harm, damage, loss anymore, and prove that you're not within their jurisdiction. Okay? Because they use this thing called minimal contact doctrine. Minimal contact means that some way, somehow, somewhere, they presume and assume under maritime admiralty law that in one way or one fashion or another that you have engaged with them and you have lent yourself by waiving your rights and joining their ranks. How do you do that? Well, let's see. You start out with a learner's permit, first of all. That's a minimal contact right there. A driver's license. That's a minimal contact. Registering for public fucking fool system. That's a minimal contact doctrine. Okay? The Social Security number is not yours. That's not a minimal contact doctrine because the IMF is not part of the United States. Doing documentation with the IRS is not a minimal contact doctrine because the IRS is not part of the United States. All right. And there's some confusion with people out there that are saying, oh, if you have this and you have that, that's what lends to them presuming and assuming they have jurisdiction under the minimal contact doctrine. All right. Let me be very, very, very clear with you. The estate does not belong to you. You have use of it. Right of use. You have right, which is what? That means there's a remedy there, right? If you have a right, there's a remedy, and a remedy is a right. Okay, why do you have a right of use of it? Because what they did in 1871 made us the preferred stockholders in the United States. They mortgaged everything. It came later to fruition that we were the preferred stockholders in 1933, where it was very clearly laid out in the Trading with the Enemy Act under 40 Statute at Large 411, which was actually created October 6, 1917, if my recollection serves me proper. Okay? This is so important to comprehend. Lawyers do not learn what I'm teaching you. They don't learn this in law school. In fact, many of the attorneys that I come across don't know shit from fucking Shinola. All right? They know process to a degree. The ones that I really am keen upon and paying attention to be really, really fucking honest with you, are their paralegals. Because paralegals get in the trenches. They get their hands dirty. They get in there and actually do some fucking research. Most attorneys do not. Their paralegal puts together the documentation and they go in and put on a grandioso fucking show in front of a mock trial, which is really a mockery of justice, right? Okay? So, now that we're all caught up on the history and how things fucking work, let's continue to press on here so I don't drone on forever and cause you to lose focus on the subject matter at hand, because what we're talking about is the law of grammar, which, as I stated in the beginning of this, is just as precise as the law in mathematics. Okay? We're not using no Common Core horse shit around here. You want to know why they push the Common Core horse shit, theoretical bullshit through the school system? To dumb fucking people down. Because it's really easy to run roughshod over people and convince them it's raining while you're pissing on their back if they're too fucking retarded to know the difference. Okay? Legal fiction laws such as the Reconstruction Act, that's the Reconstruction Act of 1871 that they're speaking of, and the implementation of the Lieber Code, that's Executive Order 100, all right? Because we're in time of soft martial law. How can I affirmatively state that with conviction? Because the one who declares the war, a war is always declared by declaration, must end it by proclamation. And you know what they did to old Lincoln, right? Little derringer to the back of the cranium. Okay, they tried to poison him. First, the Jesuits tried to poison him. That didn't work. Then they turned around and sent some young buck, half-cocked and drunk, down there with a derringer and opened up his cranium. That's how it happened, all right? Now, they say the Treaty of Paris is something that you can rely on. The Treaty of Peace and Amnesty ended the war, but that is not true. Okay? It's still there. They're still operating under the War Powers Act. They're still operating under the Lieber Code. They're still operating under the Trading with the Enemy Act. And to prove that this, after the Reorganization Act of 1871, under the Executive Order 100, that they're still operating under the Lieber Code and that they're still operating in a foreign jurisdiction, a quasi-governmental jurisdiction, all right? It looks like the government, sounds like the government, smells like the government, right? Looks like shit, smells like shit, probably tastes like shit, but it's not. It's not the government. They're an artificial entity masquerading around as government, really under the DOD, Department of Defense, under military occupation, okay? It was a hostile corporate takeover, essentially. Were instituted by Lincoln soon after and became the basis for the current laws. Now, how can I affirm once again that you're still under military martial rule or martial law, a soft martial law, because you still have the illusion of freedom because you go to work at 8 a.m., punch out at 5:30, have a beer for happy hour, and go watch some Sunday and Monday and Saturday night football, volleyball, baseball, softball, and think you're fucking free. That's called the Roman Colosseum or the Roman Circus. It's just a distraction. Give them food and bread and circus. Give them bread and water and circus. Give them wines and spirits. And then we'll march their kids off and we'll pretend that women don't have rights and we're going to do a movement for women's rights so we can justify ramping up taxation and we can justify taking their offspring out of the home and we can ingrain in them the teachings that we wish for them to have, to be just intelligent enough to go to work and not intelligent enough to question anything. It was a slick dick design. Slick dick Bill, Willie Clinton, and Hillary Clinton couldn't have come up with a design so perfect if they fucking tried. All right? This is an ingenious plan by a bunch of individuals. Probably, I would say, a total of 8,500 people run the world. And they're all from the bloodlines that devised this artifice and scheme to make the entire planet, if you will, the entire landmass, a giant fucking feedlot. Feed them, breed them, force vaccinate them, and send them to their grave. Insure the shit out of them because they're worth more dead than they are alive. And while they're alive, we will make sure that they pledge their collateral, their offspring, their flesh and blood, their DNA, their houses, their fortunes to us, and we'll insure it on the backside, and nobody will ever be the wiser. They stand to lose nothing with you being uneducated. Nothing at all. Okay? But you can change that. All right? Abraham Lincoln did not free the slaves because he wanted to free the slaves. Abraham Lincoln freed the slaves because he had to fulfill the Treaty of Ghent, or no nation would do international business with them afterwards. Okay? So the three sovereign city-states, the City of London, which again was an arson, so they could clear ground and create their own sovereign city-state, which is the head of the banking. Then you have the Roman Vatican, which is really Rome that never fell. It just simply changed names, moved into a thing of religion. They religioned themselves into what appears to be a church, but is really a military force upon the earth. And then you have Washington, D.C., the District of Columbia, the largest standing military force in the world that enforces the bankers' policies and the religioning of the Roman Vatican and cult. Okay? Real simple shit. As soon as you figure it out, it's not hard. Roman Vatican is the reaper of the souls. The City of London handles the banking and the monetization of your sweat equity and labor, and the United States enforces it, okay, at the threat of death by barrel of a gun. All right? Were instituted by Lincoln soon after and became the basis for the current laws in the U.S. Okay, you see the U.S., not the United States of America, the U.S. The U.S. is an adjective. Then you have the United States, okay? Then you have the United States of America. If you look it up in history, there are a shit ton of United States of Americas, okay? One we see in the Federalist Papers, Article 1, Section 1 of the Federalist Papers. Remember, under Article 6, Section 1, that the Federalist Papers, you can invoke and utilize the actual name of the Republican form of government that was created, which was the United States of America, with a capital T on the word the, and it was in quotation marks with a period at the end of America. All right, that's Article 1, Section 1 of the Federalist Papers, okay? Every purported act in effect today is de facto. It's de facto on the de facto side under the Reorganization Act of 1871. Remember, the power to create is never greater than its creator, which means the de jure form of Republican government guaranteed is still there. You just have to enforce it, okay? And I know it's not easy to do. Trust me, I've been in jail more than Carter's got fucking nuts, but you can do it. I'm living proof of it, all right? Every purported act in effect today is de facto based on colorable, fictitious entities created arbitrarily out of nothing without verification, lawful foundation, or lawful due process. All of such laws are not law, but rules of relationship, okay? And I want you to pay attention to these words: relationship, friendship, partnership, joint business, ship. Everything that ends with a ship, you can just about attribute to maritime admiralty, law of mercantile, law of merchant, okay? Trusteeship, all right? Grantorship, granteeship, okay? Anything that ends with a ship at the end of it, relationship, is always directly tied to commerce, commercial use. And make no mistake about it, ladies and gentlemen, commerce is war, and war is profitable, all right? But rules of relationships by force conquest originating from and existing in military martial law jurisdiction, okay? And as I said earlier, there are three types of martial law. There's soft martial law, and then there are, they escalated up to, okay, nobody's allowed to leave their house. We're just gonna, for 2 weeks, we're gonna curve the trajectory of of whatever they want to claim is going on. So we need everybody to be compliant. And then there's full-blown martial law, march your ass to concentration camps, which they call FEMA camps now, that are in the United States. Very, very large facilities where you get in, and once you get in, it's like an Eagles song, you can never get out. All right? Military martial law jurisdiction, jurisdiction of war, win-lose interaction consisting of eating or being eaten, living or dying, food chain, law of necessity. I keep telling everybody this. Necessity trumps the law. That is a military doctrine, okay? And it is a military maximum of law, and a lot of people use it. I use it all the time, you know, when it benefits me. I get caught fishing without a license. Well, first of all, the only reason I would need a license to go fishing is if I was sporting. I'm not sporting. Out of necessity for the substance of life, I have the right to forage for food. So, you know, the game warden or the officer might perceive me as a lawbreaker, Okay, but when you actually know the law, there's a clear and cut difference. I'm only taking what I need out of necessity, as I need to nourish my body as the substance of life. Okay, so I'm not fishing. Fishing is a sporting activity. Hunting is a sporting activity. Okay, I'm foraging for food out of necessity, for nourishment, the substance of life. Do you see the difference? I hope you understand what I'm talking about. And there's a lot of people that are going to be butthurt about, oh my gosh, what about the habitat staff there? Don't you believe in good habitat? And what if everybody just did what you did and just went and foraged for food out of necessity? Okay? Let me tell you something. The Heavenly Father told us the earth is plentiful and to be fruitful and multiply. The Heavenly Father is provided abundance. It's only the alleged governments throughout the world that have given you the insecurity that there's not enough for everybody to go around. There's not enough for everybody to go around, so you got to get a license. We got to approve you to put food on the table for your family. Get the fuck out of here. Fuck out of here. All right? They've also convinced you there's 9 billion people in the world. They've also conditioned you of the mind to believe that it's a democracy and that 51% of the population agrees with them, and therefore you must be the minority of the 49%, and you're going to do what we say because the 51% rule. That is not a Republican form of government, ladies and gentlemen. That's mob rule, okay? So you can argue all you want, one way or the other, about my views or what I'm saying. I could give a fuck less. Okay, I'm just here to present some facts to you, and sometimes the facts are hard hitting, and it's like wiping your ass with a cactus. It's something you're never gonna forget. All right. Suspension of all law other than complete freedom to act in any manner to eat, kill, or destroy, or avoid. Okay, right there. Again, they're telling you under martial law, the law of necessity kicks in, and you have all these rights still. Okay. Because if they denied you the right to eat, to kill, or to destroy or avoid, right? Protect your family, protect your home, protect your garden, to go out and hunt for food, if you will, out of necessity, then that would be a war crime. That would be a violation of the law of nations. Okay? They can't starve the population. Even though they're engaged in military occupation, there are rules to the engagement. All right? Being eaten, killed, or destroyed, no law, lawlessness, complete absence of all lawful basis to create any valid law. Now, what you need to understand about martial law is, during martial law, the Department of Defense or the invading army or military or force or corporation, because corporations is really what they are. So you got corporations out here murking people, which is fucking insanity. Okay? During that time of occupation, if you go read the Lieber Code, Article 2, Executive Order 100, Article 2, Article 31, and Article 38, the peaceful inhabitants are issued certificates of indemnification. I'm going to say it again. The peaceful inhabitants are issued certificates of indemnification. And here's why. Under military occupation or during the conquest of trying to conquer a nation and its people, all right, the military takes over all the minerals, the houses, the livestock, the feed, the grain, the monetary system. So those Federal Reserve notes, those instruments of debt, are really military script authorized under the DOD under the law of necessity. Okay? So, let's keep going on. I don't want to lose track from where we're going, but it seems fitting to add a nice history lesson here. Contractually, being a victim of those acting on the alleged authority granted by the law of necessity. The law of necessity, again, is by way of force. Whose gun's bigger? We're going to have a whose dick bigger contest. All right? I'm telling you right now, when the American people finally wake up from their slumber and pierce the veil that's been lightly laid upon their head, and they actually see what's going on, people are going to swing. It's going to be a hoedown. It's going to be a shit show. Tar and feathers. The bell of shame is going to come back out. The walk of shame is going to be stupendous. It's going to breed some very resilient, disciplined men and women after the aftermath, in the wake of the correction, if you will. It's coming. No lawful object, valuable consideration, free consent of all involved parties, absence of fraud, duress, malice, and undue influence. No bona fide enforceable contract, no valid enforceable nexus, absolute right to engage in any action of any kind in self-defense, complete and total right to disregard any alleged jurisdiction and demands from self-admitted outlaws committing naked criminal aggression without any credibility, and right to demand allegiance and compliance from anyone. This is martial law, ladies and gentlemen. This is what they're doing. All right? The emperor wears no clothes. They've brainwashed you in their public fool system to believe they're the authority, that they know what's best for you, that you need to run out and vote and pretend to be a Democrat and Republican and lie to yourself. Like I said, to be a Democrat or a Republican, first you have to understand it's an occupation. And second, don't people that are Democrats and Republicans actually get fucking paid? Yes, they do. They get a check once a month from the government. All right, so if you're running around like a fucking idiot, calling yourself a Democrat or Republican, you might want to rethink that again, because who does the good Lord tell you you are? You're a fucking man with dominion. He didn't say you're a Democrat or Republican, and then I'm gonna parade you around under symbolism through ideology and adult. What is it? It's not adultery. It's ideology. Idolatry. There it is. Idolatry. Where half of you will be represented by a fucking an elephant with a fucking brain the size of a pea, and the other half of you will be represented by a fucking jackass. That's not what the Heavenly Father said. He said you're going to be good stewards. Okay, you're going to be fruitful and you're going to multiply. He didn't say that I leave everything to quasi-governmental entities to rule over the people. Now, I know what the King James 16:11 Bible says. You might want to go read the Geneva Bible, for which he was caused to rewrite the Bible in the form of King James 16:11. Because when you read the Geneva Bible, it tells you that we wrestle against not men, but sound doctrines and principles and despotic governments hell-bent on ruling and lording over his people. All right? And King James removed that. Said, oh, you need to be in compliance with the government because the governments were put in place by God. Yeah, the governments that were put in place by God were we the people. Love your neighbor as you love yourself. Do unto others as you wish done to you. Don't touch what doesn't belong to you. And for God's sake, don't screw Peter's wife. Don't screw your neighbor's wife. Pretty simple shit. Okay? So what we have is man mimicking God and subjecting people through their ignorance to an artifice and a scheme that resembles law, but when tested, is in fact not law. Okay? Every president of the United States since Lincoln has functioned by executive order issued from a military martial law jurisdiction. That's Article 1, Section 8, Clause 17, the territorial jurisdiction of Washington, D.C., the District of Columbia, which is not part of the United States of America, nor is it a part of the Union of States. Okay? It's a single and separate, distinct military jurisdiction. Okay? So now that we're all on the same page and we understand that, and during military occupation, jurisdictions go out the fucking window, don't they? That's why they tell you in their Article 1, Section 8, military tribunals, if you bring up the Constitution again, you're going to jail. Okay? I've had them say that to me so many times, I just laugh. I laugh. I think it's funny. Okay? Bunch of fucking blowhard cockhounds strutting around like their shit don't stink, naked as a fucking jaybird, standing on a bench, doing banking, administering a Chapter 11 defunct bankrupt corporation for which I'm the preferred stockholder and investor in, and you think you're going to fucking bark at me? Get the fuck out of here. You must have lost your ever-living fucking mind. All right? Think about that. The counties, the municipalities, they all have DUNS numbers. They all have a code attached to them through SAM.gov now. About 2019, they started implementing SAM.gov. By, I think it was like 2020, they fully implemented it. They still have DUNS numbers. What the fuck's the need for a DUNS number? That's right. For tracking their credit worthiness, right? So they can negotiate bonds, securities, okay? Promissory notes, letters of credit. GSA bonds, GAO bonds, okay? So every president of the United States since Lincoln has functioned by executive order issued from a military martial law jurisdiction, which means that they haven't been the president of the United States, ladies and gentlemen. They've been the commander-in-chief, masquerading around as the president, giving the illusion. Martial law jurisdiction, with the only law being the law of necessity by way of force and might. You comply or die, maggot. You're a subject, serf, vagabond, vagrant, indigent. If you allow them to call you all that shit after they raped, robbed, and pillaged you and engaged in piracy on the land, and you don't stand up and sound off like you got a fucking pair, I don't know what the fuck to tell you. I don't know what the fuck to tell you. All right? I.e., the war powers. The war powers are nothing new. Indeed, they have been optional from the instant the first man thought he would hide from God, try to cheat ethical and natural law by overreaching, invade the space and territory of others, covet other people's land or property, steal the fruits of their labors, and attempt to succeed in life by win-lose games. All existing authority in the United States today derives exclusively from the war powers. Truman's reformation of optional authority under the war powers begins. Now, therefore, I, Harry S. Truman, shitbag, scumbag, President of the United States of America, acting under and by virtue of the authority vested in me by Section 5B of the Trading with the Enemy Act of October 6, 1917, 40 Statute at Large 415, as amended, Section 5B of Appendix Title 50. Title 50, United States Code is the military code, by the way, ladies and gentlemen. And Section 4 of the Act of March 9th, 1933. This is where they went pro rata. They went back to March 4th, okay? And they instituted this. But he's claiming March 9th, 1933, because that's when they decided to backdate it all the way to March 4th to encompass Proclamation 2039, making everything a financial institution, meaning that everything is engaged in commerce now, meaning that everything is either agricultural, industrial, or commercial, unless stated otherwise by what? Your intent. Your intent must be written on your documents. Private household consumer goods and for no other use or purpose is authorized. 48, Statute at Large 2, sic transit rights, substance, truth, justice, peace, and freedom in America, the land of the fucking slave and the home of the once brave, all right? Actually, it says the land of the free and the home of the brave, but let's call it what it is. A bunch of neutered, nutless, gutless sons of bitches who are highly uneducated now that are being farmed on a large plantation for the benefit of a few at the sufferance of all. The abolition of the English and American common law. Here's an interesting quote from the 1973 session of the U.S. Supreme Court. The American law in this country, the law in effect in all but a few states until mid-19th century, was the pre-existing English common law. This is known as the law of the mother country. If you go look up all your state constitutions, ladies and gentlemen, and you pull them up and you get into the state assemblies, where they're assembling how the judiciary will function, they're assembling who, what, where, when, how, and why things will be done, you will find out that the judiciary through the state assemblies is all governed by canon law, which is Roman civil law, okay? Ecclesiastical law, if you will. So there is no separation between church and state, number one. And number two is you will find that the state assemblies laid it all out, the hierarchy of the law. So it goes the Constitution, natural law, God's law, then it goes to the law of the mother country. Every state constitution has the English common law or the law of the mother country listed in the workings of the organic constitutions, okay? They adopted that law because when they came over here, they didn't have their own law. So they thought best, well, we'll use what was already established to a degree until we can get our own footing and our own foundation for the American jurisprudence on equity and the exclusive jurisdiction of equity. And how I can affirm that as well is when you look at the Constitution and you read it, it talks about equity. Okay. So America is very unique because we are kings without subjects. Okay. That was established by the Britannic Magistry, okay, and in the Treaty of Ghent, Article 10, and was affirmed by the king, right? And he distinguished the difference between the American people and the British subjects, all right? And again, we use the Sixth Amendment, Section 1, to invoke and draw in that jurisdiction and use it to our benefit. Anyway, I want you all to know that there is a clause for everybody to use and invoke in any jurisdiction the English common law. Okay, but the English common law is not what you guys think it is. It's not what you've been taught. It's fucking brutal. Go back and read some of the shit from the 1500s, 1600s, 1700s that was happening in England and tell me you want to adopt and use the English common law. All right? You're better off using American jurisprudence, the exclusive volumes for the exclusive jurisdiction of equity, all right? Where what should be done shall be done, period. End of story. Instead of the law of mercantile, the law of merchant, Roman civil law, Roman civil maxims, English common law, all right? English common law is what people call so often case law in a misnomer, which is really just case precedent. It's not a law. The judiciary doesn't have the ability to create law, ladies and gentlemen. We, the people, didn't give them that fucking power. All right? So, it was not until after the war between the states that legislation began generally to replace the common law. Roe versus Wade, 410 U.S. 113, that was overturned. In effect, Lincoln's second executive order abolished the organized English common law in America and repealed it with laws based on a fictional legal foundation, i.e. executive orders and directives executed under authority of the War Powers Act. In April 1861, the American and English common law was abolished and replaced with legal fiction laws, aka statutes, rules, city ordinances, and codes based on executive order and not the due process specified within the organic constitution existing and functioning under the law of necessity ab initio. They are all non-law and cannot validly assert jurisdiction, authority, or demand for compliance from anyone. Why? Because they're de facto. If you're insolvent, you can't enforce shit. If you're insolvent, how could you foreclose on anybody? You're a debtor. Okay, anybody bringing a claim has to be solvent. That's the whole reason for needing to be bonded. All right, and in all these cases of maritime admiralty law where the DA is fabricating a alleged crime based upon statutes, codes, city ordinances, rules, and regulations, comprehend this. They're using your Sesta K Vi trust, and they are hypothecating your credit as a creditor, as a preferred stockholder in the United States, because they mortgaged everything so they could do international business, okay? And they're hypothecating your credit into existence and hoping you won't realize what the fuck they're doing. It's called wagering. That's what they're doing. They're wagering. And in their system, underneath the war powers, they make the people, or the ones who presume and assume themselves to be taxpayers, liable when they get caught wagering. When they violate the law and are found guilty of violating somebody's rights, there's a restoration that has to happen, which is i.e. called remedy. And if that comes in the nature and the form of some type of monetary compensation, who pays it? Does it come out of the cops' pension? Does it come out of the police union's pension? Does it come out of the cops' insurance? Does it come out of the judicial insurance or the government's insurance slush funds? No. Who does it come from? The taxpayers, okay? The taxpayers end up footing the bill for their ignorance and their violation of the law. See, policy enforcers, gun-toting morons with an IQ of about 70, If they actually had to pay out of their own retirement and they actually had to pay out of their own hide a pound of flesh, they'd start studying the law real quick because they wouldn't want to ever trespass on the rights of we the people because it would cost them dearly. As it stands now, it costs them nothing. They're forced to resign and they go get hired over in the next county. Okay? We can either fire you, which will be on your record, or you could resign for reasons undisclosed, and you can go work in the next county. Choice is yours. Why do they give them that option? Why do they give them that option? Well, they give them that option for this reason and this reason alone. It's hard to find people that are willing to subject other people to the whim of someone else. It's hard to find people that are so ignorant and compliant and willing to follow orders that they'll violate their own oath, and there's not enough of them out there. So instead of terminating them and making sure they never hold a position of trust or public office or official position of confidence, what they do is they say you can resign or we can fire you. Okay, nothing's going to happen to you. We're not going to prosecute you. We're not going to bite the hand that feeds us. We love you gun-toting morons out there that don't fucking have an IQ above a single-celled amoeba. Okay, there's a need for you. So if you just resign, you can go work with Dudley Do-Right in the next county over, and you can fleece and grease everybody over there until somebody bitches, and then we'll move you, and we'll give you an opportunity to resign, and you go work somewhere else. And that's how it works. They are entirely rules of relationship, rules of commerce, maritime admiralty, law of merchant, law of mercantile, all right? I.e. organized piracy, privilege, plunder, and enslavement invented and enforced by those who would rule over others by legalized violence in the complete absence of moral authority, adequate knowledge, and natural law mechanics to accomplish any result other than disruption, conflict, damage, and devastation. In war, they're all allowed to lie to you. But they have a statute that says if you lie to them, boy, oh boy, you will be penalized. We will call this obstruction of justice. All right? What I call it is a fucking abortion of justice. An abomination. Okay? Misrepresentation and mischaracterization of the facts. It's espionage. Mixed war against the Constitution. They're working for organizations hell-bent on overthrowing the Republican form of government guaranteed by we the people, to we the people, for we the people. The established maximum of law applies. One who exercises jurisdiction out of his territory, this is very important, cannot be obeyed with impunity. Article 1, Section 8, Clause 17 is their territory and jurisdiction. All the agents and agency working on behalf of the state of, the all caps letters, okay, is in fact and does belong in the jurisdiction as stated in Article 1, Section 8, Clause 17, a 10 square mile area, military forts, arsenals, bases, and buildings and land they have acquired through a very specific process. That is their jurisdiction. That's it. No greater, no less. Territorial jurisdiction can be challenged at any time. Before trial, during sentencing, after sentencing. After the completion of a sentence, territorial jurisdiction can be challenged at any time. This is how you overturn and overthrow a bullshit case. And you know it's bullshit because they call it criminal when really it's civil. 27 CFR 7211, all crimes are commercial. Why? Because they're private for-profit, quasi-governmental organizations. They have the appearance of government, but they are not government. Masquerading around as government, utilizing statutes, codes, city ordinances, rules, and regulations that are directly tied and correlate with the penal bonds, penal sums, and the penal code to negotiate negotiable instruments, unregistered securities. and trade them on the secondary stock exchange market through New York. There is no obligation to obey and no obligation to enforce. They are swindling you and tricking you. It's the devil's trick. They practice deviling. They're using words that you think you understand that are common in the English language, and they're using them in a different form and fashion, casting spells, using spelling to hoodwink you and catch you in a snare and leave you to be the debtor while they run off with your credit. Then they warehouse your body as surety because you are in commercial dishonor under the law of mercantile, maritime admiralty law. The public debt can never be challenged. When you start arguing and quibbling instead of understanding what they're really fucking doing, you fall into dishonor. Wherefore they hold you. Because a third party is buying up the bonds that you wouldn't use your exemption on to clear. And those bonds and securities are held on the credit side of the ledger, which is the liability. Credit is liability. Okay? The debit side of the ledger is the asset side of the ledger, which belongs to you because you're a preferred stockholder. And if you'll simply go read Executive Order 100, Article 2, Article 31, and Article 28, it will become abundantly fucking clear. And if you further your studies, then go read 40 Statute at Large 411 in its entirety, and then go back and reread 40 Statute at Large 411 Section 7E repetitively and compare it to Article 38 of Executive Order 100, you'll start to be able to pierce the veil and see what's really going on. All right? Anything done or omitted under any rule, regulation, order of the President of the United States, i.e. Commander-in-Chief, is a full acquittance and discharge of anyone making the same. And he shall cause to be issued a certificate, and that certificate can be recorded at any state registrar, court clerk, clerk of the county, state, or otherwise, and shall be power of attorney. Now, what do you think that certificate is? How about that certificate of indemnification under Article 38 of the Labor Code, Executive Order 100? What do you think they're talking about a certificate of indemnity? What is indemnity, ladies and gentlemen? All right? I'm just pointing out some things. I can't change your mind. I'm not here to change your mind. You have free will. Not even the Heavenly Father will try and change your free will, so why the fuck would I? Okay? Exemptions from punishment, penalty, or harm. 10 Co. 77, Dig 2120, Story Con Laws, subsection 539, Broom Max 100-101. Applying it all to current laws. An established maximum of law states the importance of the name. Okay? In order rightly to comprehend a thing. This is so important. I use this in court all the time. Inquire first into the names. Until we can identify the thing, all right, we don't know what it is, and we don't know who it applies to. We can't move forward. All right, this is what I did most recently in Tennessee, where we did a demur, all right, and we focused on the names and the way that they construct the documents. We need clarity. We need a bill of particulars. We need point of clarification. And we support that demur with a set of negative averments and an affidavit in the form of testimony. Testimony in the form of an affidavit under jurat. And we give the prosecutor 10 days to respond because we don't have to give them 21 days. We don't have to give them 30 days. Being the actions they've already taken, 72 hours is more than sufficient. They should have the evidence readily available at their fingertips before they had ever went into the court and used a simulated legal process with sham pleadings trying to draw us in there, right? For a right knowledge of things depends upon their names. Title 3, Pleading and Motion, Rule 9A, Capacity, Federal Rules of Civil Procedure states, in pertinent part, when an issue is raised as to the legal existence of a named party or the party's capacity to be sued or the authority of a party to be sued, the party desiring to raise the issue shall do so by specific negative averment. Why negative averment? Because equity only operates and acts in the negative. That's why negative averment. All right? Which shall include supporting particulars. Remember when I was talking about the bill of particulars? Need a bill of particulars. A negative averment. We're doing a demur. Okay, that's an ecclesiastical aspect. The demur. The plea and abatement. All right? At this juncture, it is clear that the existence of a name written with all caps is a necessity-created legal fiction. This is surely an issue to be raised, and the supporting particulars, Bill of Particulars, okay, your document is going to be called the Bill of Particulars, are outlined within the memorandum. Use of the proper name must be insisted upon as a matter of abatement. Okay, plea and abatement. I was talking about it just a second ago. Plea and abatement, common law abatement, demur, negative averment, bill of particulars, memorandum. Okay, memorandum is going to be the series of facts that you lay out. And remember, in maritime admiralty law, it's a presumption and assumption. They're making the claim. You know you're not the defendant. Okay? You're the man who has an interest in the constructive trust they have created because you're a preferred stockholder. All right? And they charged up this entity. And when they charged up this entity, they need your exemption. You're going to accept all the charges, right? I accept all the charges for the value. Demand you use my exemption for post-settlement, set-off, and closure. Just like that. And in doing so, you're filling the role of creditor because you're coming in as surety using your exemption, and now you have all the rights, titles, and interest that will be gained from the bonds and securities that they issued in your good name. Creating the constructive trust. Abatement correction for all parties of an action of purported law. However, the current courts cannot correct this since they are all based on presumed, assumed, fictional law and must use artificial juristic names. Okay? This is why you do that common law abatement with a demur, with a negative averment, and a memorandum in support, and 99.9% of the time, they'll toss the case. They might not tell you this is why they're tossing the case. In a lot of instances where I help people, they toss the case and they say, oh, it was some technicality. Process of service wasn't followed properly. What's some of the other excuses I've heard? The state hasn't provided sufficient evidence to support its claim, and therefore I'm going to go ahead and dismiss this case. And counselor, you're more than welcome to bring it back when you have met sufficient burden of proof and evidence to support your claim. So I'll go ahead and dismiss it for now. And counselor, if you'd like, you can bring it back. Why is he telling the counselor he can bring it back? Because the counselor, once he makes that claim, has to bring his checkbook. And if the case is dismissed, without the ability of him being able to bring back a future claim or take a leave of court and correct his palpable errors at law in the documentation, then the attorney who's brought false claim in a simulated legal process has to bust out his checkbook and has to pay for it. That's why they get pissed off about people like myself and you guys out there that are executing this and learning this for the greater good of mankind, because it's enough of letting the lying, looting, pandering, thieving pieces of shit steal from the American people, squander away our wealth, and cast us into involuntary servitude, peonage, bondage, and slavery due to our ignorance. Okay, so we're the ones to blame. All right, we always got to look in the mirror first, because if we're going to blame everybody else, we can't possibly be the solution. But if we're the ones to blame, we are the fucking solution, and that's a good day. It's miserable to find out we've been hoodwinked, ladies and gentlemen, but until we take accountability, responsibility, and liability for what the fuck is transpiring, we're going to toil in misery forever and a day. We are the problem. Let me say it again. We are the problem. Instead, they expect the lawful Christian man or woman to accept the all caps name and agree by silence to be treated as if he or she were a fictional entity invented and governed by mortal enemies. All right? So, the author is the authority. They authored it. They created it. This all caps entity, this ens legis entity under the Sest KV Act of 1666, under the presumption and assumption under maritime admiralty law, under ecclesiastical law, that you're lost and dead at sea. Okay? That you didn't report timely within 7 years. The unknown, unnamed baby went home with mom. The infant died at the hospital, and the child is registered. All right? The child being registered by the state registrar. The state registrar, ladies and gentlemen, is a chief probate officer. A chief probate officer is a fucking judge. A chief probate officer is probating an estate. There has to be an estate before a trust can ever be created. And the evidence of that estate already have been probated is that birth certificate, bill of lading, shipping manifest, warehouse receipt. That birth certificate is a lot of things in a lot of different jurisdictions. It goes by many names, and it has many different purposes. The important thing to understand about that birth certificate is that you're the holder in due course. They owe you a duty and obligation. They must go to unlimited lengths to deceive and coerce this compliance, or the underlying criminal farce would be exposed, and a worldwide plunder enslavement racket that has held all of life on this planet in a vice grip for millennia would crumble and liberate every living thing. At this point, the would-be rulers of the world would be required to succeed in life by honest, productive labors, the way those upon whom they parasitically feed are forced to conduct their lives. Okay? The attorney craft and the very definition of an attorney through etymology is to attorn property from one and give to another. To attorn, to tear from one and give to another. And they've been extraordinarily successful at it. Oklahoma statute, since the entire game functions on the basis of the people's failure to properly rebut and rebuke and rebuttal presumptions, the issue then becomes how to properly rebut their presumptions that you are knowingly, intentionally, and voluntarily or willfully agreeing to be treated as if you were the all caps name. The all caps name is a legal construction. It's a constructive trust. Or, let's look at it this way. It's a resulting trust manifesting from the constructive trust that was created by the state registrar creating the estate, allowing trust to be created and attached to the estate. And the estate has to have what? An account number. And there's where your Social Security account number comes from, because the estate can't do business and commerce without what? An account. And then as a result, there's these resulting trusts they create through the statutes, codes, city ordinances, rules, and regulations that are directly attached to penal code violations that have penal sums on the back end of them. One angle of approach is found in the requirement for proper names to be identified in any legal dispute. Again, in your state constitutions, you will find in every state constitution that English is the language of this land, okay, or of this state. And it will further read on, in some states anyway, that on all official documents, records, proceedings, writs, manuscripts, English will be the language used on official documents. So you can, through deductive reasoning, you can realize really quickly that you're not operating in a judiciary. Okay? When they're using that all caps, ens legis, ASL type of hieroglyphics, essentially, okay, that isn't English, then those documents aren't authentic and they're not binding and they're not tied directly to the government pursuant to the Constitution and the rules of engagement. All right? This includes a mandate to correct the legal paperwork involved when proper names are provided. In regard to criminal prosecution, this is clearly set forth in the Oklahoma Statute, Chapter 22, subsection 403. Okay? In the Nebraska Constitution, in the Bill of Rights, I believe it's Article 1, Section 1, subsection 27, tells you that the English language is the language of the state, and all official documents, papers, orders, procedures, and rules shall be printed in English. No other form is accepted. Okay? When a defendant is indicted or prosecuted by a fictitious or erroneous name, and in any stage of the proceedings his true name is discovered, it must be inserted in the subsequent proceedings, referring to the fact of his being charged by the name mentioned in the indictment or information or warrant, right? Or summons. Okay, now the reason they can't do this is because the fiction cannot interact with the reality. The reality and fiction can never mix. So when you're pressing the issue through demur and through common law abatement and negative averments and your memorandum, and they can't rebut, rebuke, or otherwise, what do they got to do? They show you as a third-party intervener that's coming in with your exemption, and now you fill the roles of the creditor holding rights, titles, and interest to the accounts receivable. It's just banking, ladies and gentlemen. It's just banking. That's all it is. I can show you 1,000 ways to get remedies, statutorily speaking. And I can show you ways to get remedy purportedly using the common law. I can show you how to get remedy using the exclusive jurisdiction of equity. I can show you how to go into ecclesiastical venues and clean their clock. It's real simple. But you have to understand what you're doing, when you're doing, how you're doing it, and pick one and stick with it. I like to use everything. I like to fucking fuck around with them. I like to touch them in their butthole while they're not paying attention and watch their eyes get as big as a bullfrog. I like fucking with them. Because I think that's what I was put here on this earth to do. I think that's what the good Heavenly Father put me here for shits and giggles, for kicks and laughs, for a good fucking time. I think my duty on this earth is to fuck with public officials or quasi-governmental public officials. Remember, under administrative law, that's all under the executive branch. Okay? That's all under private, quasi-governmental. It's all under commerce, industrial, and agricultural, under the executive branch. That's a violation of the separation of powers when they're masquerading around as judges, but they're operating under the executive branch. For the attorneys out there that tell people there's not an Article 3 venue, there's still an Article 3 venue. I just pointed it out to you. The Federalist Papers 81, 82, 83, Article 6, Section 1. They couldn't abolish the organic constitution or our right to a court of competent jurisdiction and a court of record. They can never do away with it. We are guaranteed that Republican form of government. American jurisprudence in general is essential to identify parties to a court action properly. If the alleged parties to an action are not precisely identified, then who is involved with whom or what and how? Do you disclaim the trust? Judge? Judgy Poo? Ministerial administrator, are you disclaiming the trust? Because unless all parties are properly identified, this can be nothing other than a resulting or constructive trust. If not properly identified, all corresponding judgments are void. Void judgments. Void judgments. If you're just learning this information now and years ago you found yourself in a conundrum with a court case, you can go back and do a collateral attack on that judgment as it is a void judgment, as the proper parties were never properly identified. You were denied the 7th Amendment. You were denied the 4th Amendment. You were denied the 5th Amendment. You were denied the 6th Amendment. You were subject to 8th Amendment, cruel and unusual punishment. They blatantly violated their duty and trespass on the 10th Amendment, and they violated the First Amendment. You can go overturn those judgments with a collateral attack. They denied you due process of law. Pursuant to the organic constitution and the Republican form of government, you were guaranteed, under an artifice and a scheme, using a false conveyance of language to ensnare you in an artifice and a scheme to unjustly enrich their principal at your peril, to their benefit and your demise. And you can go overturn those cases. And once you overturn a case for void judgment, there's just compensation on the backside of that, ladies and gentlemen. As outlined in Volume 46, American Jurisprudence, 2nd edition, at Judgments. Okay? Subsection 100, Parties. A judgment should identify the parties for and against whom it is rendered with such certainty that it may be readily enforced, and a judgment which does not do so may be regarded as void. When they say may be regarded as void, that means that you have to challenge it. It's not just void, it's voidable, which means you have to put a little bit of effort into it. All right? Because you unknowingly and unwittingly participated without full disclosure as to the nature and cause. I'll always tell you the cause. The cause is you violated some benign statute, code, city ordinance, rule, regulation, blah, 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 or there's some presumed contract that you entered into that they will never have entered into evidence on the record. So assume facts not in evidence, right? Facts not in evidence, facts not agreed to, no contract, and requires a legal determination. Those are the 3 objections on that one. Facts not agreed to, facts not entered into evidence, and requires a legal determination. Boy, that grabs them by the fucking short and curlies. Talk about making their butthole pucker. Ah, fuck. Oh, he's got us now. Now we got to explain ourselves, Lucy. For uncertainty. Such identification may be achieved by naming the person for and against whom the judgment is rendered. Technical deficiencies in the naming of the person for and against whom judgment is rendered can be corrected if the parties are not prejudiced. A reference in a judgment to a party plainly liable, followed by an omission of the party's name from the language of the decree, at least gives rise to an ambiguity and calling for an inquiry into the court's real intention as reflected in the entire record and surrounding circumstances. Footnotes, number, and cites are omitted. All right? I need to take a little break here and wet my whistle. We'll come back here in just a little bit. We're on page 11 of 20. We're going to get through the rest of this because my intent, my purpose is to help other people ascend to the mind so we can get back to leading by example and showing the world how it's done. and stop being patronized and taken advantage of. All right? And I'm telling you right now, it takes a lot of guts, it takes a lot of heart, and you have to be mentally prepared if you're getting ready to walk down this road. If you're afraid because you might lose your house, if you're afraid because you might lose your car, if you're afraid because you might be in jail for 3 weeks and lose your job, I feel for you, because the Heavenly Father told us never be indebted to anybody, ever. Never be indebted to anybody or anything for any reason, because he's already sent his only begotten Son for all debts. Debts and sin are synonymous. It's already been taken care of. But the fucked up thing is he gave us free will. And the devil said, I'll take your challenge. I'll take your challenge. Started issuing contracts and creating this thing called legalism. Legal and lawful are two different jurisdictions. One belongs to Lucifer himself. The twisting of the language, the manipulation, the condescending ways of the attorney and the lawyering craft and their profession. That all stems from Lucifer himself. And you have free will to choose which one you will serve. Serve the Heavenly Father in a lawful manner, and keep thine statutes, and stay true to them, and keep thy commandments, or you can fall subject to the rule of Caesar. You can fall subject to the law of the Pharisees. The statutes, the code, the city ordinance, the rules, the regulations. The choice really is yours. We'll come back this evening in just a little bit after I wet my whistle and give my voice a little bit of a break. I hope you're taking notes. And I want to hear about your guys' how you persevere. I want to hear about your trials and tribulations. How you found yourself in a position where you realized that you had to shit or get off the pot. It was time to drop your cock and grab your socks and rock and get something done. It was time to keep your shit wired tight, put your head on a swivel, and start doing for yourself, because nobody else will do it for you. I want to hear about your trials and tribulations and your heartache and your hardship and what you went through and what led to your success. All right? I want to know about the processes you used to liberate yourself, your friends, your family, your community, and furthermore, your fellow countrymen. Remember, we don't prevail, the people prevail. And the people prevail because we, the people, are about his good works. We're about the Father's good works. It's never about us. Our purpose and our cause must be greater than our own ambitions. And once your purpose and cause is greater than yourself, that's when you will truly start to really prevail. And it's fun to be on the prevailing side, ladies and gentlemen. But all the glory goes to the Heavenly Father at the end of the day. It all belongs to him. So, I'll see you guys here in a little bit.